All right. As previously stated, the court found there was sufficient evidence to find you guilty, and the court found you guilty. Are you 2024 CR 007138, State of Texas versus I. King Scott? Can I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Renee Munoz on behalf of Mr. I. King Scott.
All right. And you're Mr. I. King Scott?
Yes.
All right. This came back because you informed the court that you were only entering a plea because you cannot bond out of jail. I don't want anyone to enter into pleas because they can't bond out. My understanding is there were some, I believe you feel as though it's a exculpatory, Mr. King, Mr. I. King Scott. So is the complainant here?
No, I don't believe so. State, do you believe?
Nope.
No, Judge. And I did have a more in-depth conversation with my clients regarding some of the evidence that the state has, things of that nature. In light of that, and because of that, Judge, he wants to go ahead and proceed with today's proceedings.
All right, Mr. Scott, can you raise your right hand for me, please? Do you
Yes.
solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
I. King Scott.
All right, Mr. Scott, do you understand you have a right to jury trial?
Yes.
Do you understand if you want a bond reduction, that your attorney could file a motion for a bond reduction, the court would hear it and make a determination of whether your bond should be reduced or not?
Yes.
And knowing that, do you still wish to proceed with this plea?
I still wish to proceed.
All right. As previously stated, the court found there was sufficient evidence to find you guilty, and the court found you guilty. Are you proceeding with sentencing?
Yes, Your Honor. With the certain caveat, if I can make a request.
Yes.
I know that TAP may be ordered with him in custody as a condition of his probation, Judge. And I know that the honorable court and the judge has the offense report and has some history as regards to Mr. Scott. There's been nothing indicative of him using any drugs. I asked him about any drug usage in the past. He's denied all drug usage. For this reasons, if the court upon sentencing is going to consider a TAP evaluation out of abundance of caution, we ask that that be done out of custody, Judge. I think there are some people that really need the TAP evaluation. There's nothing indicating that he is in absolute need of that now, Judge. And I don't want to take away from someone more deserving of a TAP and getting help that actually needs it. And it's been indicative of them needing help. Mr. Scott has denied all use. And in sentencing, if the judge wants to word on that or wants some more information on that, I'm sure he'd be glad to present that. But I just wanted to note that for the court in advance of sentencing.
All right, state, and reviewing the police report and the stipulations, I don't see anything in the police report or stipulations to suggest that alcohol or drugs were involved. Is that correct?
Yes, Your Honor.
All right. Mr. King, have you ever used any type of narcotics?
No.
Marijuana?
Yes, in the past.
Okay. Alcohol?
I haven't drunk in 8 years.
All right. Why not?
I just quit.
Why did you quit? Was it causing issues?
No, I just stopped.
All right. Do you have any family here in San Antonio?
I have a daughter.
And what is her age?
She's 21.
All right. If you're released, do you have a place to stay?
Yes.
Where? And when I say where, I should say, who would you be staying with?
With myself.
All right.
I have my own apartment.
All right. And that apartment is still available?
Yes.
All right. Anything else from either side?
Nothing from the state, Your Honor.
Nothing from the defense, Judge.
All right. The court will sentence you to 3 years in the prison, suspended and probated for 3 years. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. Proof of employment. Within 30 days. There's to be no employment as a home health care provider or with minors. There's an affirmative finding of family violence. There's to be no contact with Lauren Briones, the BIPP course. How far did you go in school?
Some college. I have a degree in business administration. I'm certified as a massage therapist. I do construction work, so I have some
So when
license.
was the last time you've been a massage therapist?
I've been here eight years ago.
Okay.
That's about the same time.
So when's the last time you had full-time employment?
I've always been employed. I stay out here. I take care of myself, so I'm always employed.
Okay.
I have a job. As soon as I leave out, I just call my boss and I'm working back.
All right.
Construction.
All right. I'll do 100 hours of community service restitution. You can pay that off if you like. It'll be at $7.25 per hour. I always suggest the San Antonio Food Bank because they usually have a shortage. So if you want to do that, you can.
Okay.
And I'm going to order $50 to the Family Violence Center. And I can only order $50, but I tell you what, if you do not want to pay the $7.25 per hour to the San Antonio Food Bank, if you donate another $50 to the Family Violence Center, I'll deem your community service hours satisfied. So that's completely up to you. Legally, I'm only able to order what I've ordered, okay?
Thank you.
You're welcome.
Where do I-
There's going to be field visits one time per month for 3 months. Then at probation's discretion. Probation, is there anything else?
Okay.
Is there anything else you need from the court to be successful?
No, I just want to, where do I show my proof of employment at?
Oh, probation is going to go over conditions with you
Okay.
and they'll let you know where you need to be.
Okay.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it?
Yes.
Did you sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing, Mr. Scott. Whatever brought you to the place that brought you to this court and caused you to be here, you need to start looking internally and change. Otherwise, what's going to end up happening is you're going to be back before me on a motion to review. You understand?
Yes.
It's probably best that you not involve yourself in any other relationships until you work on you. You understand?
Yes, ma'am.
And this court to be successful on probation, communication is key. If you have an issue, let your probation officer know. They're telling me, your counselors told me that you don't have an alcohol or drug issue, which we do have limited resources. So I don't want to take up an officer's time to do a tap if that's the case. However, if you see yourself getting ready to use, pick up the phone, call your probation officer and let them know. And they're going to try to help you. You understand?
Yes.
But if you don't let them know, can't help you.
I understand.
All right. Good luck to you.
This case was not just about a plea. It was about whether King Scott understood the weight of what he was accepting in court. The main issue was a felony family violence case. And before moving forward, the judge made something very clear. No defendant should plead guilty just because they cannot afford to bond out of jail. That was the biggest courtroom moment. The judge stopped the process, questioned him directly, explained his right to a jury trial and a bond reduction hearing, and only continued after Scott confirmed he still wanted to proceed. From there, the court accepted the plea agreement and handed down the result. 3 years in prison, suspended and probated for 3 years, with strict conditions, reporting drug testing, proof of employment, no contact with the victim, a family violence finding, and a ban on weapons. But the strongest part came at the end, when the judge warned him to look inward and change before he ends up back in court. The lesson is simple. Probation is a second chance, but it is not freedom without responsibility. If this courtroom moment made you think, hit like, comment your opinion, and subscribe for more real courtroom breakdowns.